practice.
So good afternoon and welcome to everyone. Assisting our team, Sir Dennis, President Saunders, and myself is Larissa Pena, who is Judicial Counsel attached to the CCJ and as well Legal Officer and Executive Manager of the Caribbean Association of Judicial Officers. While Larissa just gets the PowerPoint on proper mode, I'll just introduce what we're going to do, give you a little bit of a map. What we propose to do this afternoon is to deal with the areas of the overriding objective of pre-action protocols and ADR and of issue identification and treatment in three parts. The first part will be the overriding objective, followed by a second part on pre-action protocols and ADR, and a third part on issue identification and treatment. I will lead the first part, President Saunders the second, and Sir Dennis the third, but all of us are involved in all parts. There will be an initial segment in each of these parts where there'll be a presentation, a little more formal, where we will discuss some slides and some content. And then for each of these parts, we have dedicated a 10-minute Q&A, where we hope that you will have questions and ask those questions. Now is the time to ask your questions, please. And no question is a bad question. Every question is a good question. This is new for many of you, if not all of you, and so now is the time to ask your questions. All that we ask is that what we ask and say is done in a respectful manner. We undertake to be respectful in our responses, and we ask that of everyone who is here. In the last session on issue identification and treatment, at the very end, or coming close to the end, we have a case study, and we are volunteering you, Chief Justice, the President of the Bar Association, and one other person who you all will choose, or the Chief Justice will choose, to assist Sir Dennis in a part of that. We had hoped to do a live poll, but that has not been possible this afternoon, regrettably, but never mind, it's not possible.
Sorry, Justice Jaminar, perhaps I can deal with that now. The third person, I'd invite the President of the Court of Appeal, Sir Michael. I think you're with us. Are you prepared to join us in that third session? He may be on mute.
So, all right. So
I wasn't sure I was going to be on that long, so I would beg off if I could.
Okay, very well. So let me quickly identify. I'm looking at the list of.
Turn down.
Is Justice Charles with us?
Now about the #1 most popular whole life insurance plan available through the Columbia.
I'm here, but I'm sorry, I will have to leave also.
Okay, well, we're striking out. So let me deal with it on the phone, Justice Jaminar, and I'll identify the third person by the time we get there.
Yes, we have a lot of time before we get there. We have a few hours. So,
sorry, one more interposition, I'm sorry, but I'd like to ask our administrator, Mrs. Neely, can you mute everybody, please, so we don't have these interruptions?
Yes, sir.
So please mute everybody. Thank you. Over to you, Justice Jaminar.
Okay, great. Thank you. So, Ms. Neely, once you have not muted Sir Dennis, the President, and myself, I think we're good to go, and the Chief Justice maybe, but all right. So a bit of housekeeping. At the end, you'll get an electronic evaluation. It'll be posted in the chat. Please fill it out. It won't take you more than maybe 5 to 7 minutes. Now, if we were in person, I would ask a question and ask for a show of hands. How many of you did your pre-reading? Silence means consent. So we take it that everyone did the pre-reading. You had a case summary to read, and you also had about 14 pages to read in a little booklet. So we hope that you've done the pre-reading, and so you've come into this session somewhat prepared. Well, I think that's enough for introductions. Let's try and move on to part 1 of what we want to present this afternoon. Larissa? the overriding objective. We say that the overriding objective is about getting to the heart of the matter. And in this afternoon sessions, the objectives that we have set for this part are, at the end of this session, you will become aware of and knowledgeable about both the interpretative and executory mandates of the CPR's overriding objective. And that in the context of three things: substantive and procedural justice, dealing justly with cases, and 7 principles, which we'll come to in a moment. So those are our objectives. Now we need to say to you that in a very, very short time that we have, we're trying to cover a lot of material, and there's certain amount of compromise we have to make in terms of depth to cover breadth, but we are going to try and do our best. So moving along, let's begin with our judicial oath. The judicial oath very much describes who and what we are. In a way, it embodies our professional or judicial identity. And significant in the oath is to do right to all manner of people after the laws and usages of the Bahamas. What that means, I think, in this context is that our oath reminds us that when the CPR is introduced in July of this year, that we are sworn to uphold it. That is because it constitutes part of the laws and usages of the Bahamas, the Commonwealth, when these rules come into force. The next thing that we need to think about is to establish some what we call overarching context, because the rules don't just appear on the legal landscape in a vacuum. They appear in the context of certain constitutional and ethical values. In the Constitution, of course, the Constitution is supreme, Section 2. Section 15A talks about the protection of the law. Section 20, though cast in the context of criminal justice, speaks to a fair hearing within a reasonable time. Now, this fair hearing standard is a constitutional standard that, even though it is specifically identified in relation to criminal trials, under the preambular value of the rule of law and in the context of the protection of the law rights, that fair hearing standard is also applicable squarely to civil proceedings. So constitutionally, these rules are cast in the framework of constitutional imperatives to ensure that all court users get the benefit of timeliness and fairness. But even more than that, I know that your jurisdiction, I believe, had embarked on a code of conduct for yourselves. I may be wrongly informed, but I think that that has not as yet come into full fruition. We hope that sometime soon it will. But never mind that. The Bangalore Principles of Judicial Conduct, which govern all judiciaries, both civil and common law, they have certain principles. And one of the core principles is described as the principle of competence and diligence. And this principle includes preparation, expedition, and efficiency in the performance of judicial functions, including the delivery of reserved judgments. Let's take a little deeper look into some of the overarching context. What these things that I have described point us to is 4 core principles: competence. And when we talk about competence, I think there's a little feedback. I'm not too sure why. But when we talk about competence, that includes the just and fair management of cases. It also includes the principle of efficiency. And notice what efficiency is. It is managing cases in a timely and expeditious fashion within established performance standards. And as we go along, we'll see the rules establish performance standards. And very importantly, maximizing the economic use of available court resources. We're going to see how the rules provide specifically for that in the overriding objective in just a moment. It also makes efficiency, effectiveness, however, is a little different from efficiency, and it speaks to managing cases in ways that are proportionate to the matters in issue. In the last segment, when we come to identification of issues, you will see how this is relevant. But not just issues, but also time and resources. When we talk about proportionality a little later on, we're going to just explore that a little bit more. But very importantly, decision-making must further the objectives of the CPR, and in particular, the overriding objective. And finally, the principle of impartiality or fairness, the principles of impartiality or fairness, which is to say that at every stage of a matter, a matter must be conducted fairly and impartially, and this in relation to all court users, not just attorneys, not just parties, but all witnesses, indeed, all persons with whom we have contact with in the judicial process. And in fact, it goes so far as to say even in and out of court. But for the moment, we're trying to establish some overarching context for the overriding objective. Having done that, let's move to the overriding objective itself. This slide and the next slide just document the overriding objective, because some of you may want to use these PowerPoints later on. And so I've included these here so that you could come back and see it. I've tried to highlight some of the main principles. If we move to the other slide, we'll see that part 1, the overriding objective, all has 1.1, and what you're looking at now is 1.2 and 1.3. So the overriding objective structurally, you can say, is built in 3 ways. It's 1.1, then 1.2, and 1.3. 1.1 basically talks about what it is. Can we just go back to that, Larissa, for a moment? Thank you. 1.1 talks to what it is. That is to say, it speaks to the idea that the singular purpose of the overriding objective is to deal with cases justly. And then 1.1 goes to tell you, what does this dealing with cases justly mean? If we move to the next slide, we'll see that 1.2 talks about what do you do when you apply the overriding objective. We'll look at that in a little bit. And then 1.3 speaks to something very, very important, which again, we will see when we move to the next 2 parts, which is ADR and issues, the duty of parties. So that's an overview of the structure, because when we interpret the overriding objective, we have to understand that it begins by saying what is the core principle, and then it talks about how you are supposed to apply this principle, and finally it talks about the duty of parties. That's an overview of the overriding objective. So let's go a little deeper into it. We like to talk about the interpretative and executory mandates of the overriding objective. What does that mean? And you will notice that I'm starting with 1.2, and it's for this reason. Whenever we talk about the overriding objective, the first thing we have to understand, even before we know what it is to understand the breadth and depth of its application. So 1.21 says that in applying the overriding objective, the court must seek to give effect when exercising any power, any discretion, and when interpreting the rules. So that's just about everything. Whenever you are exercising a power under the rules, whenever you are exercising any discretion under the rules, and we're going to hear in the next 2 parts how central discretion is in the choices we make, and whenever we are interpreting these rules, well, you must seek to give effect to the overriding objective. But 2 goes even further. The rules shall be liberally construed to give effect to the overriding objective. And in particular, it focuses even more to secure the just, 1, 2, the most expeditious, the fastest, and 3, the least expensive That's a costs and resource issue determination. So when you have to apply the overriding objective, we come back to 1.1 in a moment to deal with cases justly. When you have to apply it, when are you applying it? You're applying it to everything. In every exercise of a power, in every exercise of a discretion, in interpreting every rule. But you have to apply it with a focus. The focus is to secure just, most expeditious, not just expeditious. the language chooses to put most expeditious, and not just inexpensive, the least expensive determination. All of these words and all of this language is intended to start sending a message. That is the cultural change we spoke about in the last session. How do you do everything in the shortest and most timely way? How do you do everything in the least expensive way that uses the minimum amount of resources necessary? So we can say that in the what, in the application of the overriding objective, we're going to talk about just determination in a moment. Interpretation, application in order to achieve expedition and minimal costs. All right, that's the breadth and scope of it. Well, what is the overriding objective? The overriding objective is very simple, or simply put, not simple, to deal justly with every case. 1.1, the overriding objective of these rules is to enable the court to deal with cases justly and at a proportionate cost. So you notice right away that costs are integral to the overriding objective. Remember earlier on, I pointed you to what 1.2 said, most expeditious, least expensive. Here you see it again. What does this mean? It means that dealing justly with a case is not limited to the sort of explicit statements of what justly means that we're going to look to, but it is essentially a matter of judicial discretion. Why do I say that? I say that because everything is going to turn out to be a balancing, a weighing, and a choice making. When I was a CPR judge for just about 8 years, I was asked to I came into the judiciary, and one of the reasons that when I came in, one of the projects was to clear a backlog of 10,000 civil cases. My docket was 1,200 matters running for years. That was the backlog. And then every year in Trinidad and Tobago, I think we have 5,000 or 6,000 new cases every year that were distributed among 10 civil judges to be cleared. And what you discover very, very early on is this dealing justly is about balancing, weighing, making choices, being able to juggle what we're going to look at in a moment, 7 core factors, and to make choices that move a case along in the process that is described in the most expeditious, the least expensive way in order to deal with the case justly. So let's just go a little further along. 1.1 also gives us 6 explicit principles. Principles of proportionality, equal footing, expedition, fairness, of saving expense, of enforcing compliance, and the appropriate use of court resources. Dealing justly with the case includes, so far as is practicable. Again, that's a question of discretion, of weighing and balancing these principles. I'm not going to read them with you. That's what I hope you would have done in preparation for this session. The point I want to make in the limited time that we have is to draw to your attention that the rules provide these 6 expressed considerations that you have to bear in mind all the time, every time you exercise the power, exercise discretion, or interpret the rules. Interpretation, therefore, means application. So whenever you are applying the rules, whenever you're making a decision, whenever you're exercising a discretion in the rules, these are what you have to know. So what I would say is, and if we just move on to the next slide, it makes it a little, I think, simpler for us. You have to, my advice to you is this: memorize those 7 key principles. You have to know them with your eyes closed. You have to know them inside out. You have to get a feel for their tone and quality. In every case, they're going to apply in slightly different ways. But these are the key principles that inform dealing justly with the case and the exercise of the powers, the discretion, the interpretation and application of every single rule in this new CPR. You must know and understand, what does it mean? What is the principle, the concept of proportionality mean? You have to get a feel for that. What does it mean to have parties on equal footing when you have to decide how many witnesses or what costs or how much disclosure? What is just, what does expedition mean in a case? Remember, it is the most expeditious. How do you do all of that and be fair? How do you save expense? How are you always thinking about the least expensive in 1.2 to save expense, to save costs? Very important. How do you enforce compliance? How do you enforce compliance? Let's go back to the slide before, please, Larissa. 1.12F at the bottom there. Enforcing compliance with rules, practice, directions, and orders. Now, let me make this point. That is what it means to deal justly with a case. And we're going to come to that in a little bit when we talk about the difference between substantive and procedural law. To deal justly with a case includes enforcing compliance with rules, practice, directions, and the orders that you will make in the CPR regime. Let's go back, Larissa.
If I could just make a point here, Peter.
Sure, of course.
Because it is something that has come up from time, that used to come up from time to time in the Eastern Caribbean. A person would flout the rules. And when the hammer is about to fall, they say, but the overriding objective is to give justice, to for cases to be dealt with in a just manner. If you strike out my case, then that isn't just because I have a good case. The overriding objective doesn't mean that you throw out the rules and you simply give some kind of palm tree justice. The overriding objective also embraces enforcing compliance with rules, practice, directions, and orders. So I just wanted to make that point.
No, absolutely, and the President and Sir Dennis, we have learned in our own lived experience with these rules, and over the years, as we have intervened in other jurisdictions, that one of the greatest reasons for the failure in achieving the potential of these rules is a hesitancy and reluctance in relation to what is your 1.12F. And because of the argument that the President summarized, and that'll come in all formal fashions, so it is worth underlining. Can we move along, Marissa? So Dennis, you want to say anything on this? Sorry, did you want to say anything on this, Dennis?
I was trying to unmute myself. You see, many people think that doing justly means having a soft heart and trying to be, give people a break when they are on the wrong side of the rules. But it's just the opposite. Doing justly includes enforcing compliance with the rules and court orders. Because every time somebody does not comply with a rule or order, and the court gives that person a chance, you undermine the principle of fairness to the other side.
Right.
So the doing justly with cases involves strict compliance, enforcing compliance with the rules. Yeah. And that's a very important cultural change that needs to be absorbed by both the judicial officers and the practitioners before the court.
Yeah, no, absolutely. Thank you, President and Sir Dennis. So that when I put up these 7 key principles, they extracted from 1.12, but we cannot urge you to really just embody these. You need to understand. You have to sort of, like how a cow chews on its cud, and it takes grass. It actually has 4 stomachs, and it digests and brings it back. When you chew and chew and chew, you really, really need to chew on these, because you also have to apply them in a cluster. It's not one or, it's all at the same time. And the truth of the matter is, the overriding objective creates for judicial officers an enormous responsibility in terms of balancing, as I said, weighing, and the exercise of discretion. But the judicial officers who are good in the CPR have, in my experience, have mastered these 7 key principles of the overriding objective, which constitute what it means, as both the President and Sir Dennis have both reinforced, what it means to deal justly with the case. So there's no, well, let's move along. Let's move to the next slide, because the next slide segues nicely into what I want to talk about.
Judge, just giving a time check.
Yeah, yes, thank you very much, Larissa.
Welcome.
So, substantive and procedural justice. What is substantive justice? Substantive justice is to define, create, or confer substantive legal rights or legal status, or to impose and define the nature and extent of legal duties. Basically, substantive law, substantive justice is, what we do at the end, at the very end.
I see Bertha's on too.
But I think somebody needs to mute who is still, who is with us. Thank you. And sometimes we think as judges that's our role and function. We're here to deal with the substantive law. But the rules of court are a source of procedural law. And the function of procedural law is to prescribe and regulate, and I really want to emphasize those words, prescribe and to regulate the machinery or manner in which legal rights or status and legal duties may be enforced or recognized by a court of law. So what the CPR is going to start to do, which is part of the cultural shift, is to begin to place at a level of parity procedural justice and procedural law. The 2 branches, substantive and procedural, are complementary and interdependent, and the interplay between them often conceals what is substantive and what is procedural. But we must remember that it is by procedure that law is put in motion, and it's procedural life, it puts life into the substantive law. Rules of court, your CPR, therefore, rules of court of fundamental importance, is of fundamental importance. You deal with it as a CPR. CPR is of fundamental importance. So the good administration of justice. What's the point here? The point is this. Do not consider procedural justice as some second tier or second level justice. Procedural justice is on an equal footing with substantive justice. And the CPR is lifting it to that status, recognizing that status, and not just inviting us, but almost mandating us to honor it. Can we move along, please, Larissa? In a Court of Appeal decision, Bernard and Sibelak, you have the citation there, it went to the PC. There's a little quote from it. Under the CPR, it is no longer right to say that the court's function is to do substantive justice on the merits and no more. The overriding objective adds the imperatives of deciding cases expeditiously and using no more than proportionate resources. So what the Privy Council is kind of saying here is this preoccupation with the end result. Hold on. You need to recognize that doing justice includes making sure that the overriding objective is achieved, and that its imperatives are met. And it identifies in particular expedition and the proportionate use of resources. I'm not going to dwell on this too much because the proportionate use of resources in the second session with President Saunders and in the final session with Sir Dennis, those two sessions are all coming out in part of this proportionate use of resources. It's just fundamental, and notice how the Privy Council has identified it. So moving along, the Court of Appeal in Trinidad and Tobago has, in a unanimous decision in Bernard and Sibelak at the appellate level, observed that under the CPR, justice, therefore, is not distinct or superior to the overriding objective. That's the point I was on earlier. Doing justice under the CPR is to enable a case to be dealt with justly in accordance with the overriding objective. Now, that's just the Court of Appeal of Trinidad and Tobago, but it's making a very important point. It's the point that Sir Dennis and President Saunders were making earlier. When you come to the CPR, the overriding objective is saying how we must approach it, including making orders, giving directions, and enforcing those orders and directions to ensure expedition. Remember, most expeditious, least expensive. Let's just pause on least expensive. Every time a matter is adjourned, there's a cost to a litigant who has to pay their attorney to turn up on 1, 2, 3, 4 occasions. CPR says you have to be aware of that. And therefore, you may think of it in the box of adjournments, but actually it is also about achieving the overriding objective of most expeditious and least expensive. That is why we said in the first session, adjournments are anathema. Why are they anathema? Because the overriding objective clearly says most expeditious, least expensive. Hence, adjournments are anathema. So this idea of adjournments are anathema, don't take it as if that's a little carve out we're talking about. That change in culture is rooted in the overriding objective of these rules. And if you can do that, then you can achieve the potential of the rules. And it redounds to the benefit of the litigant, the court user. Why? Because their costs are down. If cases are done quickly and at the lowest cost, litigants benefit. The system benefits too, but litigants benefit. Let's move along. So as I come very much to where I want to end this little session and open up for some comments, first from the President and Sir Dennis, and then from you, some questions that we hope, is to sort of end on the idea of the new role of the CPR judge, which is what the overriding objective begins in a way, and it's part one, it's what it sets the tone for. The fundamental ideological shift, as we said in the first session, is from lawyer-driven to judge-controlled. As Sir Dennis said, when you file your case and it comes before me, it's now my matter. You've come into my court, it's my matter. That's the fundamental ideological shift. Court of Appeal Trinidad and Tobago, again, in another case, observe, while it is accepted that in adversarial litigation, judges must be cautious to always preserve the core judicial values of independence and impartiality, it is equally clear that the role of the judge under the civil proceedings rules as CPR is significantly different from what previously obtained. This is apparent from the overriding objective and the provisions of the CPR itself. So here's the Court of Appeal recognizing this fundamental shift and recognizing that it is located centrally in the overriding objective. The CPR 1998 have brought about this is the language of the Court of Appeal, a seismic shift in the roles, responsibilities, pay attention to that, and powers of the court to manage and shape litigation. Remember in the session one, we spoke about projectization of a case and to control, notice the word, to control its unfolding in terms of issues and timing. And that theme of issues and timing, we're going to come to part 3 with Sir Dennis. But in managing and shaping litigation, it's also about issues, but it's also going to be in part 2, we're going to hear from President about other forms of intervention. Larissa? So to end this little part on the overriding objective, CPR 1.3 says something that's very, very important. It speaks to the duty of attorneys and parties. They are to render assistance in furthering the overriding objective. So 1.3 says it is the duty of the parties to help, to assist the court, to further the overriding objective. And it also says to the court, in applying the rules to give effect to the overriding objective, the court must take into account a party's failure to help. So if a party is not helping the most expeditious and the least expensive disposition of a matter, well, the court, it says may, discretionary, may take that into account, maybe in orders for costs, maybe in whether they impose default orders, maybe in relation to different forms of sanctions, maybe in relation to timelines. So this duty of attorneys and parties is framed in the rules in an interesting way because there are two parts. There is the first sentence part, which is a positive duty on attorneys and parties to help. When the president comes to talk about pre-action protocols, you're going to see why he and we recommend them, because of if you want to achieve the fullness, the full benefit of 1.3, he will discuss that further. I'm not going to elaborate, but you will see that. So one is the positive obligation, but then the second is a power and a responsibility, albeit discretionary, in the court to assess whether you have been fulfilling your duty, and if you have not, to take it into account. Well, this is, of course, a lovely segue into what we're going to come to next, I hope, which is case management and our conversation with pre-action protocols, ADR, and issues. Only to note that when you look at the CPR in square brackets, as at the bottom of the slide, appears what you see there, repeated verbatim. Part 1 ends with parenthesis around part 25. And it says part 25 deals with the court's duty to forward the overriding objective by active case management. And both President Saunders and Sir Dennis today will begin to touch on this. I'm just establishing for you a hard line that within your rules themselves, you cannot delink part 25 from part 1. You can't delink it, even if that was not there in parenthesis, you can't delink it. But part 1 is putting down in black and white that, hold on, listen, this overriding objective business that we're about is directly linked to part 25. So we have a little time, President and Sir Dennis, before we set section. What I've left enough time. It's 38 minutes since my running time, and we have about 10 minutes, no, a little less, about 8 minutes of my running time. I wanted to use that for both you, President, and Sir Dennis, to say whatever you want to say about what I've tried to cover, and then use that opportunity to give participants time to post some questions or make some comments that someone will bring to our attention. So may I invite, in whatever order you prefer, President or Sir Dennis, any comments you want to make?
Sir Dennis, go ahead.
All right. Well, I would just like to leap onto the last slide that you have before you, because from time to time, I'm going to be using the phrase that the case management and the implementation of the overriding objective is a team sport. That is not something which belongs to the judges only. The rules, the overriding objective itself brings the parties and the litigants into the family, into the team of managing cases to get a just and fair result. And I think that that is an important principle to understand. It's not the judges against the lawyers. Far from it. The judges and the lawyers are on the same team, working together to get a just and fair result to disputes that come before the court. Thank you.
Yeah, before we throw up the floor, I would just want to make just one comment. We've spent, or we had allocated 45 minutes to part 1. It's a short part, overriding objective. But part 1, allied to parts 25 and 26, are the most important parts of these rules. If we understand how those 3 parts work, then we are lawyers. We could understand the rest of the rules. We're just reading and understanding them. Because those parts infuse every other aspect of the rules, so that you can't spend enough time in grappling with what it means to implement the overriding objective, what the court's powers of management mean for active case management in order to illuminate the overriding objective. So I just wanted to make that point. So maybe we can throw open the floor now for any questions, comments.
Well, I've got one question in the chat group. The question is this: how, if at all, is the perception of impartiality of the court in the administration of justice and the equality of litigants before the court affected by having an inner and outer bar before the court and the physical seating of the inner and outer bar before the court?
Well, that's a sort of question that goes to history, tradition, what we want to change, what we understand and what we don't understand. I mean, the reason for an inner and outer bar and all of that comes to us historically. We all know that, and I think what the participant is asking is whether the rationale for that persists. It also has to do with court structures. For example, if you go before the Privy Council, the bench sits at the same level as the attorneys. For those of you who have gone from the Bahamas, who have looked at it, it's all live. They've changed their structure. They sit in a semicircle and everybody sits there, and everybody just wears suits. There are no wigs. So this question moves not just into inner and senior, junior, but it tells you the question of robes and wigs, and you sit high, you sit low. And for myself, I think that it's very much for every jurisdiction to work that out. What does the society think they're ready for? What undermines what we call inclusivity? That is to say that court users feel enough of a part of the system that facilitate fairness, as the question asks, that court users don't feel that if you have a senior lawyer sitting closer to the judges, they get an advantage, whereas a junior lawyer, who's your lawyer sitting further away, is at a disadvantage. Those are all legitimate concerns that I think each jurisdiction has to negotiate and work out for themselves. I don't think there is a pat answer, but Sir Dennis and President, you may have different thoughts on it.
Yeah, well, I wouldn't spend long on it. We have another person who has their hand up, Ms. Bostwick. But suffice it to say that, as you said, they're traditions, they're customs, and one cannot imagine that a judge's impartiality would be clouded by showing a certain deference to a person who is a senior practitioner, deference in the sense of having them have a different gown, having them sit in the inner well of the court. That's a kind of form of courtesy that you can consider it. But the judge naturally will treat in the same scales the arguments of somebody from the inner bar with those from somebody from the outer bar.
Yes, okay, I think we have time maybe just for the more questions, so
Yeah, I see Miss
Bostwick?
Bostwick's hands. Yeah.
I think we have an interloper in our midst with that dog in the background. Hopefully he's not too distracted.
Yes.
Go ahead, Ms. Bostwick.
Thank you very, very much. I hope I'm not the interloper. I thought that
No, I was not referring to you at all.
I appreciate being
the
given
barking
the
of the
opportunity to have a
dog.
question. I don't know what presenter it was, but one of you indicated a difficult cultural shift in that we will need to understand the need to adherence, complete and absolute adherence to the rules and the orders that are made by the court. I appreciate that and obviously understand the need and sort of agree with it, but I do have concern about what that will mean in the transitional phase as we all become accustomed to the new rules, practices, etc. Because in the harshest application of that could mean matters being struck out as we all adjust. And I don't know that as we are learning these rules, I'm deeply concerned about the timelines for learning these rules, practicing them. I'm 25 years, I'm an old dog, I will have to learn this new trick. But I'm very concerned about the implications that can have. So is there any transitional phase and period where this harsh application of the rules or absolute application of the rules is going to be somewhat measured as we all come to terms with it?
Before the chief maybe responds and speaks about transitions, if he wishes to, I think we want to disabuse you of the idea that it is harsh or absolute. I think one of the things that we've tried to say in this first part is to talk about fairness, if you recall. Is what, can we go back, Larissa, to slide, can we go back to slide 7 or 8, I'm not sure which one it is, but the point is that the exercise of the discretion is to be fair and reasonable when in the balance several considerations. So it is an exercise of a discretion, and one assumes that judges who have to exercise the discretion will be fair and proportionate, reasonable in the exercise of discretion. What it also means, however, and this is what I think Sir Dennis was trying to say to us, which is the slide before us still, is that it ought to be collaborative. It's a team sport. So attorneys need to be able to say, well, you know, 2 weeks is a little short, can I get 3 weeks? Ultimately, it's for the judge to decide, well, maybe 3 weeks is too long in all these circumstances. So I don't want you to think about it as harsh and absolute and imposed. Unfortunately, this slide has a photograph of a gavel, kind of the hammer drop in. But I think that in the exercise of discretion, the principles allow for fairness and reasonableness in the orders that are made. There is a difference between what is fair and reasonable and what is excessively permissive. And I think that is where maybe your concern is, but at the same time, court users have to come to terms with the fact that we can't keep doing the things we've been doing, the way we've been doing things, if we want things to change. President, Sir Dennis, you want to say anything?
Yeah, judges are not beasts, and we're not advocating that they act as beasts. What is good about these rules is that they give enormous discretion to the judges. And as long as you read the rules, you make a good faith effort at following the rules, you're diligent, there is one line that you mustn't cross. And that is when the judge says the case is set down for the 15th of January. You better be in court on the 15th of January to have that case heard. Or if the judge says a case management conference is set for the 6th of March, that is a date you have to keep. So, but there are, in the rules, just as in the old rules, there are provisions for seeking extensions of time, but those are not to be abused. So have no fear. It is like learning to swim. You have to be in the water, and it is only after the rules have been proclaimed and you begin to practice them that a lot of things will come home to you and you will get a better sense of how to grapple with them. So there's no need to be fearful of the rules.
So Dennis, the last word with you.
Well, my contribution, it's no point repeating what both yourself and Adrian have said. So I'll give an example. When I first started practicing, appeals from the magistrates' courts were heard by a divisional court of the High Court. 2 High Court judges heard magisterial appeals. And then there came a time when the rules were changed and appeals had to go before the Court of Appeal, which meant that the entitlement, the title of the appeal had to change. The first time the court sat, after the new rules were enforced, the Chief Justice had a sort of a teaching session, and he assisted in the amendment of all of the rules that were in default, all of the pleadings, all the applications that were in default. But he said, I will allow one other opportunity for you to get used to the new rules. And the second time the court sat, he went through the same procedure of assisting the persons who were in default to comply. But on the third time, the hammer dropped. And at that time, I don't think that anybody could have complained that the court was unreasonably harsh, because the court had taken care, and that is what we would expect would be part of the attitude during the transitional period, where, as I use the phrase team sport, if somebody from turning has a problem, it's a different thing trying to communicate with the court a week or 2 in advance than to allow the day to arrive and ask for adjournment on that day. So to my way of thinking, it's a question of sensitivity, courtesies, and common sense as we try to navigate this new. And the other thought I wanted to give, to answer the questions about the respect afforded to QCs. You see, the rules specifically say that the court must see that everybody is on an equal footing. So giving respect to seniors and expressing courtesy to persons who deserve it does not imply that the beneficiaries of that respect will be treated in a manner which makes the application of the rules unfair. So one has to, I think, come around to expect that institutions will do their duty fairly and impartially, and in accordance with, well, as I said, customary behavior about giving respect where it is due, but ensuring that at the end of the day, that the junior at the back of the courtroom does not receive rulings or treatment which is not fair and proportionate. Thank you.
So thank you very much, Sir Dennis. Well, we had 55 minutes for this first session, and my timer says it's 55 minutes and 25 seconds running. So we're well on time. I'm just going to stop this timer because we're going to segue now into Larissa, the second session, and I'll put the timer on for the President, Pre-Action Protocols and ADR. President, over to you.
Okay, yeah, thank you. All right, in this segment, we are going to look at a number of measures that help to, as I put it, animate the overriding objective. Mechanisms in order to carry forward the overriding objectives. One of these is pre-action protocols. You don't have pre-action protocols as part of your rules, but I think it is helpful to give you an indication of what pre-action protocols are, how they are being used in Trinidad, for example, and how they carry forward the overriding objective so that the Chief Justice could consider whether he wishes to have a practice direction that will incorporate pre-action protocols. Next slide, please. Okay, so these are the objectives that we want to achieve during this session. We want to expose you to some of the discrete measures or tools that bring out the overriding objective and the transformational culture that are infused in the rules, and that do so by promoting and facilitating settlements. We want to describe the enabling framework that is instituted for implementing these tools, these measures. We want to demonstrate why adoption of these measures is useful, is even critical. And then we want to look at the impact of implementing these measures on the overriding objective. Next slide. Okay, so as I said, pre-action protocols were introduced by a practice direction, and the practice direction is there. In fact, it's in the Civil Code Practice, which was edited by David Imambro and myself. And I'm sure that Chief Justice Archie would happily provide you with that practice direction. The concept is to enable parties to seek information from and to provide information to each other about a prospective legal claim, so that it's the objectives are to encourage the exchange of early and full information about the prospective claim, to enable parties to avoid litigation by possible settlement, and to support the efficient management of proceedings. Next slide. Okay, now, of course, compliance with pre-action protocols is obviously not required in matters that are urgent or where a period of limitation is about to expire. So that where it is not urgent, where you are not faced with a limitation period about to expire, compliance is the norm. And if compliance is not adhered to, then it is taken into account when the court decides to exercise a power under Part 26, which deals with the general powers of the court, or under Part 71, which deals with costs. So parties are expected to act reasonably, promptly, in exchanging information and documents, and in trying to avoid litigation. Next slide. All right, so what is it that is contained in a pre-action letter? The litigant comes to you, the lawyer, tells you what his dispute is about, gives you his side of the story. The defendant, the prospective defendant is John Brown. You formulate a letter to John Brown. In the letter, you say you're acting for this litigant. You give concise details of the claim sufficient to enable John Brown, the recipient, to understand and to investigate the claim without any further information. You ask in your letter for prompt acknowledgement of your letter. You enclose copies of any essential documents that your client is relying on. You identify and ask for copies. You ask John Brown, the prospective defendant, of any essential documents that John Brown may have touching and concerning this claim. You advert to the possibility of mediation. You say, well, look, we could go to mediation on this matter if you like, if it is a claim that is susceptible to a mediative outcome. And you draw attention to the court's power to impose sanctions for the other side's failure to treat in good faith with this letter that you have written. So all of these things are contained in the pre-action protocol letter. Next slide. Now the defendant gets this letter, and the defendant has a responsibility to respond to the letter, either by accepting the claim, yes, I owed this guy the money, and if you give us a little bit of time, we would pay it. Or yes, I acknowledge liability. My car did damage his vehicle on Swanson Street. And so all of this assists in having the matter resolved even before it lands in the court. The defendant, prospective defendant, would also, if they consider that what John Brown told you, sir, is preposterous, well, you identify which of the claimant's contentions are in dispute. You enclose copies of your own documents, which help to shed light on the matter. You also enclose copies of the documents identified by the prospective claimant, or you give an explanation as to why you're not enclosing them. So there's a full kind of discovery before even the matter is put in the hands of the court. Next slide. Now, there are actually forms or templates that have been created in the practice direction that would allow you to craft a protocol, a pre-action protocol letter, if the claim is, for example, for a specified sum of money, or if it's for a road traffic accident, or if it's for defamation, or if it's for judicial review, so that you don't have to reinvent the wheel. You can simply adopt the template which is there and just flesh it out. Next slide. Okay, so that's pre-action protocols. The rules also make specific provision, well, not also, because they don't make provision now for pre-action protocols, but they make specific provision for ADR. Some cases are actually better resolved via some form of ADR than through the court system. I remember once we did a case, I did it when I was counsel with Henry Ford, a Silk from Barbados. He was leading me. And it was a case involving some French people in Union Island, one of the Grenadine Islands. These are well-heeled clients. They had some dispute among themselves. We were for the claimants. And long trial, what, 3 days, 4 days? We led our evidence, and then the other side came up and had to be cross-examined by Mr. Ford. And after Mr. Ford finished cross-examining that guy, in the evening, we went to our little conference, Mr. Ford, myself, our clients. Our client, the lady said, you know, Mr. Ford, I don't need the case anymore. You could drop the case. I was just so happy that you made that son of a bitch look like the liar that he is, that I'm not interested in the case anymore. They could take what they want. And it taught me a profound lesson. There's some litigants who just want to be heard. They're really not so much invested in a big federal court case. They simply want a voice. They want to be heard. They want somebody to be held accountable in whatever manner. And so that is what ADR can provide. It can provide avenues for treating and resolving disputes in a manner that does not involve a statement of claim and a defense and a case management conference and a scheduling hearing and a big court case where people come and give evidence and all of that. You can cut straight through all of that through some appropriate measure of dispute resolution. Next slide. The authority for ADR, the legislative authority, is grounded in Part 25.11. The rule states that the court must further the overriding objective. Come back to the overriding objective. The court must further the overriding objective by, among other things, encouraging the parties to use any appropriate form of ADR procedure, including in particular mediation, if the court considers it appropriate, and in facilitating the use of such procedures, so that the rules themselves embrace ADR and regard it as a duty on the part of the court to further the overriding objective by encouraging parties to use appropriate forms of ADR. Next slide. One of the appropriate forms of ADR is arbitration. And there are some cases that are tailor-made for arbitration. I remember again, when I was counsel, I did a case, a very complicated building contract dispute. And happily, the contract was one of these contracts that provided for arbitration by a member of the Royal Institute of British Architects. And we went through that arbitration, and I couldn't help saying to myself again and again, it's a lucky thing this case didn't have to go before Justice so-and-so, because Justice so-and-so had been recently appointed, and he was a DPP. And he really didn't have, with all great respect to him, much of a clue outside of criminal matters, because he had come up through the criminal justice system, and he was not the most adept. And this was a case that involved complicated facts and procedures and so on and so on. And it occurred to me that it was really a very good thing that we went to arbitration on it. Now, many of us judges, we feel that because the matter is filed before us, that we have no choice but to hear the matter, even if, when we consider it, we think that, well, maybe this might be a good case to ask the parties, well, why don't you go to arbitration on this? Because you can get an arbitrator who has far greater subject matter knowledge than I do, and you can even build in to the arbitral reference that the losing side can appeal to the Court of Appeal. So that is something that I want you to think about as one measure, one way in which you can further the overriding objective by, in suitable cases, offering the parties the choice of going to arbitration. Next slide. Okay, encouraging referral to arbitration. As I said, it doesn't undermine the judicial function. If anything, it shows a measure of sophistication in your management skills, that you would have the perspicacity and the confidence to refer all or part of a matter to arbitration. Next slide. And these are the benefits. It would lighten up your court docket, and it would allow for the parties to have someone with specialized knowledge of the subject matter address the dispute which is before you. Okay, next slide. All right, so we come to mediation. That is the more often utilized way of dealing with ADR. And we have found that there are some disputes that are very appropriate for mediation. Sometimes you have landlord and tenant disputes. The tenant wouldn't pay the rent, the landlord wouldn't fix the roof, and they end up in court. When in fact, each of them has a gross, and you really want to have a mechanism for each of them to talk through the gross and to sort things out, rather than to spend considerable amount of money on each side to go to court and to have a court hearing and, you know, have all this time running when you could have heard the dispute and resolved it through mediation. Motor vehicle claims, especially where there's no counterclaim, some breaches of contract that are, you know, you have a little default on your either side, family disputes, disputes between long-standing partners. All of these are very appropriate matters to be referred to mediation, and that is something which we should also bear in mind at the case management conference, whether this is a dispute which we can refer to mediation. I'm not sure what is the mediation infrastructure that you have. That's another issue, but we could talk a little bit about that. Next slide.
President, just giving a time check. We're about 16 minutes in.
Okay, good. All right. Next slide. Okay, just a little bit about mediation. Mediation helps to satisfy interests as distinct from determining rights. This is a bag of oranges, and it's a trite kind of example, but it brings out very nicely the distinction between mediation and litigation. Suppose this bag of oranges had been promised to two different people. Each of them agreed to buy it, and the vendor was a little scampish, so he took money from each of them and he, you know, put down the bag of oranges there, and then there's this big fight whether it belongs to A or B. Suppose further that, well, look, A and B had to go to court. A court has to determine who has the right to the bag of oranges. So the court might look at, well, whose contract was first in time, or who first cemented their contract by paying the money, or all sorts of rules that the court has for determining whose right is it to own this bag of oranges. A mediator could sit down and say, well, but okay, ma'am, what you wanted the oranges to do? And she might say, well, I make juice, so I need the juice to be able to make juice and sell. The man might say, well, I have pigs and I wanted those oranges for the peel to feed the pigs. And the mediator could say, well, okay, you know what happened? You take the oranges, you squeeze out the juice, and then give the squeezed out orange to the gentleman who has his pigs. And it's a win-win situation. So you satisfy interests, you don't determine rights. And that's the big advantage that you could get from a mediative settlement. I mean, that's a trite example, but it nevertheless brings home the fact that as opposed to what goes on in a courtroom, in a mediated settlement, you can actually have a win-win situation. Next slide, please. Okay, so in order for mediation to function effectively, you need to have some training for the bench and also for the bar. because you need to appreciate how does a mediator's role differ from a judge's role in encouraging a settlement. Because I've heard some judges say, well, I do mediation in court. No, you don't do mediation in court. You might utilize some mediation techniques, but you can't be a judge and be a mediator. It's impossible. You can't do the same thing at the same time. Because, for example, a mediator can caucus with one side behind the back of the other side and say, well, look, I think that they wouldn't accept that. But, you know, if you propose that, then that is probably something that they would accept. A mediator could do that. A judge can't do that. That would be a demonstration of apparent bias. So it's important that we know what a mediator does, how a mediator's role is different from the role of a judge. It's also important that we know what is counsel's role in a mediation. In a Caribbean country that shall remain nameless, I heard once that there was a mediation and the mediator was there with the two lawyers. The clients were nowhere around. You can't conduct a mediation like that. Counsel's role in a mediation is to take a back seat because it is all about trying to produce a settlement between the parties involved in the dispute, not between counsel. It's not counsel's dispute. Under what circumstances should a judge refer a matter to mediation? You need to know a little bit about that, the benefits of mediation, but we spoke a little bit about that as well, that it can deal with interests as distinct from determining legal rights. Next slide. Before I deal with the mediation settlement rate, I should say something about, so Dennis was actually the first person to introduce mediation in the Caribbean. And I was in the very happy position that he asked me to head up the mediation committee to implement it. And I was in an even happier position that I was a trial judge that was responsible, among other trial judges, for making mediation orders. And I looked at a speech in preparation for this that I gave in 2002 to remind me of what we used to do. And this is what I extracted from that speech. I said at the CMC, I would provide the litigants with the roster of court-approved mediators and invite them to select their preferred mediator. I would encourage the parties to choose the mediator right there and then. If the lawyers didn't have the list of mediators, I will print a copy of the list for them because I operated with a printer right next to me and ask them to agree on a mediator. Sometimes they would agree right at the bar table, which I would like. If they couldn't agree right there, I'd send them out, go on with the next case, tell them come back to me in 15 minutes, and then they would come in and tell me who is the mediator that's selected. If there was deadlock, I would nudge them to agree on a mediator that I would select. The point is that there and then, I want to be able to get the name of the mediator so that I can put it in the template. I have an order template, put in the names of the parties, the name of the mediator. I would print that order, initial it, initial 3 copies, give one to each side, send one to the mediation coordinator. So right there and then, you have cut through all of the bureaucracy. That mediation is on the way. A copy is with the mediation supervisor who will then contact the parties in order to have the mediation machinery set in motion. The Eastern Caribbean Supreme Court has had excellent results with mediation. In Grenada and St. Lucia, mediation is particularly robust. The international settlement rate for matters referred to mediation is approximately 40 to 50%. In the Eastern Caribbean, in the first year or so, we had a settlement rate of close to 70%. Just imagine that. 7 out of 10 matters referred to mediation, bam! After a 3-hour session, those cases are no longer on your docket, gone. And the rate was 70% because we used to cherry pick the cases and refer the juicy ones, those that were easily capable of settling. After we began to become more aggressive with the cases that were referred, the settlement rate came down a little bit, but still, when you have 50% settlement rate, that is still a huge advantage to have, because next slide, please. Or just before we get to early neutral evaluation, well, I probably should get on to neutral evaluation at this point. Because the whole aim is to try and lighten your docket list. Early neutral evaluation, that is referred to in your rules. It doesn't depend on, but it is aided by a docket system. And I gather that you have almost a full docket system, because when the cases get to you after the defense is filed, you stay with the case until the case is finally disposed of. That is excellent. It sets up very nicely early neutral evaluation. ENV, early neutral evaluation, allows the assigned judge to, after the defense is filed, to make an assessment that this is a case that could benefit from early neutral evaluation. So after you make that assessment, you then send the case to another judge who is not going to be hearing the case if things break down. But you send that case to another judge who can then call in counsel and the parties and frankly and fully discuss with them the chances of success of the claim and or of the defense. The ENV judge is not constrained because they would not be hearing the case, and so no question of apparent bias arises. Trinidad and Tobago has used this very effectively, and they knock out a lot of cases through this use of neutral evaluation. This is part of your rules, and I would encourage you also to utilize this as one of the ways of, as I say, animating, bringing to life the overriding objective. Next slide. Early neutral evaluation is, as I said, is particularly referenced at part 26.11d, where the court is empowered to take, it's a rounding up provision, but it specifically mentions early neutral evaluation in that regard. Next slide. Okay, so why is this emphasis on settlement? Well, I was idle enough to ask how many cases were filed in the Bahamas, civil cases in 2019. That's before the pandemic. 1,848. How many judges, civil judges are there? How many judges doing civil trials? 9. 9 judges can't try 1,848 matters. So we have to find ways of dealing with these cases in a manner that will get them off the docket. And this is why there is this heavy emphasis on ways of facilitating settlement, ways of encouraging ADR, because it is, you can't try your way, you can't litigate your way out of your backlog. You can't expect to try all of the civil cases that are filed. And all of them are never actually tried. What the rules actually does is it provides organized mechanisms rather than arbitrary attrition. It provides organized mechanisms for getting rid of those cases which need not result in a trial. So there is the ADR, there is the early neutral evaluation, and if you adopt it, there is the pre-action protocols. So these are all mechanisms in order to try to ensure that at the end of the day, the number of cases that are filed is roughly equal to the number of cases that are disposed. I think that's the last slide, is it?
Yes, President.
Yeah.
We
Okay.
are about 2 minutes to the 30 mark.
All right, so we're on track. Okay,
Yes,
so
we are.
thank you very much. So I don't know if there are any questions, comments, or if Peter or Sir Dennis, you wish to add anything?
I can add a very short comment, President. when the rules were introduced in Trinidad, Dick Greensdale, who worked with the Wolf, with Lord Wolf to introduce the rules in England, spoke to us. He drafted our rules. I think he was instrumental in Sir Dennis, in your rules, in your jurisdiction also, in drafting. And one of the things he told us is, you know, for the rules to work, only 10% of the, actually he used a much more robust figure, but only 10% of the matters filed should go to a full trial. So what does that mean? That means that we have 1,000 plus matters filed in 2019. Only 100 and something supposed to be going to trial. 800 to 900 have to be disposed of. So President, what you are sharing with here is central to the success of the rules. And remember, it's not just getting rid of matters in the sense of getting rid of them, you know, it's disposing of the matters justly, but using ADR, whether it is arbitration, mediation, pre-action protocols, or the early evaluation that you spoke about. So I just want to say that this is not on the periphery. This has to be put front and center of what you all do. And I also want to say that to really urge you all to think about the pre-action protocols, because it will also serve something Sir Dennis is going to come and talk to about in a little while now, actually, narrowing issues which needs early identification of issues as well as early disclosure of documents.
A question in the chat group.
Yes, sure.
Do the pre-action protocols apply to pro se litigants?
Yes, but if, of course, they are hamstrung in complying with the pre-action protocols, then, of course, the court would take that into account. One of the things with these rules is that they assume that pro se litigants would get some assistance. And where that is not possible because there's no robust system of legal aid, then the court would naturally have to take that into account, because part of the overriding objective, you deal with cases justly, you deal with people on an equal footing, and of course you can't allow for a pro se litigant to be disadvantaged on account of the fact that they do not have a legal representative.
Could I just make a comment on that question? Because there are some courts who have a help desk within the court, within the registry, particularly if there's a legal officer or somebody with a lot of skills in managing cases who can provide assistance to pro se litigants.
Do you, in your collective experience, I think my question is, have you found pre-action protocols to actually achieve the objective, which, as you say, is to crystallize the issues much earlier, and therefore avoid litigation altogether, or if it is commenced, to trying to promote a settlement? I know that in my discussions with a lot of my English colleagues, where they introduced pre-action protocols, there did seem to be a fairly consistent view that they were not terribly successful under Lord Wolf's reforms, because what they did was they front-ended a lot of costs, and they front-ended a lot of work up front, and they took a lot of time. And the overall impression was that at the end of the day, these pre-action protocols became almost robotic, and they didn't really promote settlement. You just had to comply with them in order to protect yourself on costs. So I'd be interested in your views, the three of you, on how you found these pre-action protocols to actually be effective.
Okay, I leave that with Peter, who would have had that experience as a trial judge.
Yeah, to a certain degree, yes, but a lot depends on the judges. What the pre-action protocols achieved, in my experience, was really forcing the parties, even when they had to come to court, to disclose a lot more. because of now you see in the UK, the compliance with disclosure is a much greater part of the legal culture. So that the idea of pre-action protocols in a system that is one which is solicitor driven and in which documentation is forthcoming and shared and litigation comes out in spite of that is a very different culture from ours, where we have conducted our litigation often with minimal, if no disclosure. So I think part of why it is different here and there is because of the existing cultures. But I also think even if it did not result in direct settlement, it did have an impact in forcing much greater disclosure when cases were filed, that in my experience helped me narrow issues. Because often people, I mean, it's almost a Judge Judy scenario, you know. People come to court, and when they disclose the documentation that they're relying on, a judge can look at this and ask a lawyer, I mean, where are you going with this? Is this the document? Is this the evidence? How does this support this case? And quite often, faced with that, at a case management conference, the lawyers would say, well, can we have a chance to talk about the case? And they come back and they settle the case. But what facilitates that is early disclosure. So to answer you directly, I would say, one, the culture is different in the Caribbean, but two, pre-action protocols facilitate disclosure that helps us narrow issues and even settle cases at CMCs.
I will be making a comment on that during my presentation, so I will save it for later.
And I see another question in the chat. Is the trial judge ever made aware of the ENE assessment by the third party judge? Nope. That's a no-no, big no-no. Is mediation paid for upfront by litigants in jurisdictions where the CPR are now enforced? If so, do you find this a deterrent to mediation? In the Eastern Caribbean, our mediation fees, I imagine they've raised them now. But when we started in 2002, the mediation fees were very, very nominal. And each side paid a certain amount. I think it was $250 at the time. I'm not sure how much it is now. Some of that went to the mediator, because the mediators were a bunch of freshly trained persons, some drawn from the bar, some from public sector, some were teachers, some were accountants, and so on. And they were all over the moon to be part and parcel of the justice system. So that for them, it was almost a form of civic service to practice their skills as a mediator. So they were paid this, not what was really a nominal amount for a 3-hour session. And it was an amount which was well within the, which could be afforded by the litigants. And if there was a settlement, as in at least 50% of the times there were, saved the litigants' costs. But I know that we have a lot of lawyers here. Mediation doesn't mean that lawyers don't make a lot of money, that we squeeze a part of the ability of lawyers to earn. You speak with the lawyers in Grenada or in St. Lucia, the volume of cases that are heard, you make up for volume what, and not just volume, but for you make up in satisfaction of your client, what you would otherwise might have gotten in stringing a matter out over a long period of time and getting a more substantial sum of money from it, so that it is a win-win situation. You have satisfied clients, you hardly earn less because there is far more throughput of cases, and the docket of the judges is lightened because the judge gets rid of a lot of matters through the mediation experience.
President, I'm just going to ask us, Larissa has been very kind, but we don't want to take up too much time from Sir Dennis, and I think we're a few minutes over. So
No,
if we could wind up.
Yeah.
Okay.
Just allow me to take 1 minute to say to the persons who are joining us, I have circulated a draft practice direction establishing court-connected mediation. So you should have received it if you're a member of the bar. I would invite you to read it, review it. I have had some input from some of the major participants in mediation and ADR and the stakeholders, but I would welcome the response of the bar on that draft practice direction. Yes, Sir Dennis.
Thank you very much. Now, Larissa, do I start right away?
Yes, I think we need to, Sir Dennis. Larissa will, yes.
You know, all of the sessions are interconnected and interrelated. So can we have the next slide, please? At the end of this session, you will become aware and knowledgeable about the critical importance of early identification, analysis, and treatment. That is the prioritization of issues, and in particular, understand the importance of narrowing the issues to be resolved, be exposed to techniques for narrowing the issues, and be aware of the impact that narrowing issues have on the overriding objective. Now, during the course of this afternoon's discussion, these principles have been discussed in both of the previous presenters in their sessions. Narrowing the issues is sometimes considered to be a skill that has to be developed and nurtured. Next slide, please. Now, narrowing the issues is a team sport to improve justice delivery. Why? Access to justice has been threatened throughout many countries, and I presume it might be the same here, because more cases are being filed without a proportionate increase in the number of judges. There's substantial backlogs and delays. The cost of legal services are increasing. And there's an imbalance in resources of litigants, which sometimes exposes some to vulnerability if there's endless procedural skirmishes and technicalities. And there's a generally reduced public confidence in the justice system. Now, this is partly what the overriding objective has addressed, because it introduces a cultural change aimed at improving the quality of justice delivery. And we must always bear in mind as we consider these issues that objective justice involves the pursuit of truth. Now, we've spoken about the culture of lawyers changing. And what this involves really is reducing emphasis on the traditional adversarial system. So lawyers can no longer be just the mouthpiece of their clients. They have to exercise an active duty to pursue the just resolution of disputes. Their duty to the court and to the idea of justice takes precedence over their duty to their clients. And they have to exercise their own discretion in the applications they make, which will use the court's resources. Narrowing the issues and duties of disclosure is an important part of that exercise. You're not supposed to abuse the process of the court. And as we've said earlier, you must comply with the rules and orders of the court and conduct cases efficiently and expeditiously. And most importantly, there is the duty to confer with the other side to reach settlement or to narrow the issues for trial. But this is not a one-sided issue, because the culture of the judges must change as well. The judge must be more proactive. The judge cannot sit down in his chambers or her chambers and wait for applications to be filed to take action. They have to encourage settlements, and they have to encourage the parties to confer. They must actively manage and take responsibility for the timely and fair disposition of cases. So basically the judge has to assume the responsibility of this. Now, part of that, as we're going to discuss today, is identifying and narrowing the issues for determination. And when trials are necessary, they must confine those trials to real issues of significance. Next slide, please. Now, narrowing the issues is part of the new culture, court culture. Because when one looks at the case management orders, to the extent that they were before, the case management exercises did not specifically target that principle. But I think we'll find, as we navigate this further, that narrowing the issues to be resolved expedites a fair disposition of cases and saves expense. And in many instances, it facilitates settlement. Next slide, please. Now, as has been said by both of my colleagues, we always have to start with the overriding objective, which is to enable the court to deal with cases justly and at proportionate cost. But it's important to emphasize here the concept of what I call a team sport, because it is the duty of the parties, the lawyers, to help the court to further the overriding objective. But Part 25 mandates the court to further the overriding objective by actively managing cases. And one of the methods of doing this is to identify the issues at an early stage. Next slide, please. Now, what is the definition of narrowing issues? I have identified on this slide 4 instances when one could say the issues have been narrowed. The first one is when all issues that are irrelevant to the resolution of the main issue in dispute are eliminated from the proceedings. Then issues are also narrowed when parties are not required to prove facts on which they agree. Issues are also narrowed if there's agreement on all or some of the legal principles that are relevant to the adjudication of the dispute. And issues are also narrowed with an issue which could determine the outcome of the case is resolved. And I put at the bottom of the slide, can you add something more? Because as we go through this discussion, there will be other activities which narrow the issues and proceedings. Next slide, please. Now, as I said, because this has not been a practice which was fostered under the traditional or current way of practice, these are skills that have to be developed. And the first thought is that issues can be identified and narrowed at various stages of the proceedings. So for example, after the filing of the defense, that is the first opportunity where the court sees what is the claim and what is defense. And reading of the pleadings may start a process of identifying what are the issues, definitely, and sometimes of narrowing the issues. But the next stage where issues can be identified and narrowed is after discovery of documents or the filing of witness statements. And very often, the documentary evidence may be sufficient to indicate what the outcome of the case should be. And often the filing of witness statements might reveal that the factual difference between both sides is less than might have appeared before the witness statements were filed. Now, the next thought is very difficult to identify and narrow issues if the legal standards are not clear. And it is also equally difficult if there is uncertainty about the facts, so that the pleadings are expressed in general rather than specific terms. Now, one of the values of the pre-trial protocols is that it improves the quality of pleadings, because before the case actually is filed, the parties have had this exchange which will assist them to identify what are the issues that are really in dispute between them, so that if they are unable to reach agreement, at least they can be more specific in framing the case that needs to be determined by a judge. Now, a value of issue identification is that it is also crucial to discovery, because this also narrows the issues. Standard disclosure rule, CPR, I presume that you have the draft rules with you. At CPR Part 28.4, parties must disclose documents which are directly relevant to the matters in question in the proceedings. Now, in order to determine what is directly relevant, the issues have had to be previously identified. And the same thing applies, even more importantly, when dealing with the power of the court to order specific disclosure. Because Part 28.5, paragraph 5 says specifically that an order may require disclosure only of documents which are directly relevant to one or more matters in the proceedings. And in Part 28.6, paragraph 1, it says that the court must consider whether specific disclosure is necessary to dispose fairly of the claim or to save costs. So again, identifying the issues plays an important part in determining what needs to be disclosed, and it prevents the prolix disclosure of information and introducing irrelevances in the trial. Now, issue identification is also relevant in determining the admissibility of evidence, because evidence must be relevant. And if the issues are identified, it facilitates the making of orders to admit or to exclude evidence on the grounds of relevance. So, and as you would have seen on these issues, each of these consequences relate directly to one aspect of the overriding objective or another. Next slide. Now, how do we go about this? Issues define the legal or factual contentions of the parties, and they focus the court on the area of dispute, but they can also indicate the areas of agreement. Now, this is critically important in managing litigation. Clearly defined issues guide the court in ruling on ancillary questions such as scope of discovery. By clarifying areas of agreement and disagreement, the parties may be better able to assess their positions and promote settlement and aid rapid adjudication. And issues must be defined before they can be narrowed or refined. And as I had mentioned earlier, uncertainty of the facts and the applicable law are prime sources of difficulty in defining issues, because a limited knowledge of the facts may contribute to poorly defined issues at the commencement of an action. Now, this really is my answer to what is perceived by many practitioners as one of the obstacles to the enjoyment of these rules by the use of the term front-end loading. But the knowledge of the facts and of the legal principles involved at the beginning of the case are critical to how the case proceeds, or whether there can be a settlement or not. Next slide, please. Now, both the lawyers, the attorneys, the parties, and the courts are obligated to address this issue. Now, CPR 1.3 directs that the court may take into account a party's failure to help in applying the overriding objective. So we've already discussed that the parties have to help, but the court gets involved. And in part 71, it specifically states in the rules that in deciding cost orders, the court may take into account the conduct of a party. So here we have the rules, and here we have techniques of encouraging or enforcing compliance. Now, another very important issue is how statements of case are presented before the court. I've noticed in the pleadings that have been sent to us, we've noticed that there has not been a practice, or doesn't seem to be a practice in the pleadings that I've seen, of filing documents with the pleadings. But CPR Part 8, Rule 7, and Part 10, Rule 5 specifically require the parties to clarify and narrow the issues in their pleadings by stating, by admitting, by denying relevant facts, and identifying or annexing necessary supporting documents. Now, what this does is that when the defense is filed, it puts the court in a position, a strong position, of understanding what the issues in dispute are and what issues are not in dispute. And because of the disclosure of relevant and supporting documentation, there is also an indication of where the justice of the case is going to go to. Now, again, on the issue of narrowing issues, Part 26.2 means that attorneys have a duty not to make pleadings prolix and not to include in their pleadings allegations which are irrelevant to the just resolution of the case. Because the court has the power, even on its own initiative, as provided by CPR Part 26.31, to strike out pleadings which do not add value to the development of the case. Now, this is a very important in dealing with narrowing the issues in pleadings. In fact, I saw some pleadings in defamation recently where a politician in a public address accused another politician of taking bribes in relation to a criticized activity. And when the civil claim was filed, it was defended by a discussion as to whether the activity that had been engaged in was reasonable and proper. And the question is, what does a court do with pleadings like that? Does a court allow the trial to occupy several days on matters which may not have any relevance to the determination of the issue that is to be resolved for the proceedings to come to a just conclusion? So the duty of counsel and the vigilance of the court are very important issues and techniques in keeping the issues narrowed and facilitating the overriding objective in dealing with these cases justly. And as I mentioned before on the part 28.8, the parties have a duty to make disclosure, and the court has power to compel. Now, all of these are issues.
Chief, sorry, just giving a time check.
Oh, I'm going too slow, right? So,
Well, we're at a 25-minute mark.
okay. Wow, thank you. Let me hurry up then. Let me move on to the next slide. Let me move on to the next slide. Okay. Techniques of narrowing the issues. Now, this also may be discussed later when we're dealing with case management conferences. But the court may require the lawyers in preparation for a case management conference to file agreed statements on facts and law. The agreed statements that on what facts and law are not in dispute. To file agreed statements on matters which might otherwise require interlocutory proceedings. Agreed statements of opposing witnesses, expert witnesses who have conferred to narrow the issue, and agreed statements on what issues, if any, remain for trial. Now, this is part of the obligation of the court to encourage the lawyers to collaborate and confer with each other. Then the court may prioritize and dispose of an issue which could resolve liability of the whole or the part of the matter. So, for example, if when there's a personal injury claim, a traffic accident, and when the pleadings are read, it turns out that the person who is was a driver, his defense may or may not have disclosed an issue of a defense to the case. But the real issue in the case is whether there is vicarious liability. And the court could decide whether, if prioritizing a disposal of the issue of vicarious liability would resolve the entire matter. Because if the court rules that there's no vicarious liability, that might be an end of the case. And if the court rules that there is vicarious liability, it may also have an impact on how the rest of the case proceeds or might be settled. Then the court has a power to enter judgment on the whole or the part of a claim. And this could occur where a statement of case, either for the claimant or the defendant, fails to state the claim, or if no material facts need to be resolved. so that the judgment can be delivered as a matter of law, with or without a hearing. And as I've mentioned earlier, the court may also be able to rule on whether evidence is relevant. And if evidence is excluded, it may leave the party in a position that essential facts cannot be proven. And I've given an example here as to when situations of that might occur. And even if the matter has to go to trial, this may have an impact on reducing the number of witnesses to be called or giving directions for limiting cross-examination and limiting the points of law that require to be addressed. Next slide, please. Now, the court can order parties to file agreed statements on matters which are relevant to the issuing of narrowing and settling the issues. I've mentioned that already. So I think that the slide is here, which you can review later on. These points, I think, were included in my last slide. Next slide, please. Now, how does the court go about this? And when does this occur? The first CMC must take place not more than 12 weeks after the defense is filed. And the defense must be filed not later than 56 days after the matter has been served. So here you have a performance standards set with the rules. And one of the important mechanisms is that the court can analyze the pleadings and evidentiary matter, which is on record, as I've just discussed earlier, and send a checklist to the parties to prepare the specific types of agreed statements which I've mentioned before, which will facilitate the identification and narrowing of the issues, or perhaps even settlement of the case. The next slide, please. Now, I thought that in driving home the concept of identifying and narrowing the issues, that a case study might help. And so we circulated the synopsis of a file which is prepared. And I wanted to...
Mr. Dennis, it is also embedded on this slide if for any reason you wanted to refer to it, okay?
Oh,
Larissa, it is embedded it is embedded here. So if you wanted to open it, Larissa can open it for you.
Well, let her do it. Let her do that. Just as a quick reference to anybody who might not have read the dispute. And Larissa, how much time do I have? I've been rushing a little bit.
You have about 13 more minutes.
Okay.
I actually have to open it up because it's not actually working. This is it here, but it's not working.
Anyway,
but I can pull it up if you like me to.
Yes. Well, let us start off on the premise that parties have read the synopsis. And so the first question that I was going to put is, having read the synopsis.
Larissa, can you move to the next slide, please?
Yes, please. Thank you, Peter. Having read the synopsis of the fish farm dispute, can a court narrow the issues without further information?
Now remember, Chief Sir Dennis, you have 3 volunteers. Remember, we volunteered 3 people, so you can call upon them. The Chief Justice, the President of the Bar Association, and the Chief Justice nominee.
Yes. Well, I think that we should have very briefly, in 1 or 2 minutes, a commentary from each of the 3 rapporteurs with a statement and a reason for the statement. Chief Sir Brian, do you want to start?
Well, the problem, Sir Dennis, is that I read this last night and I have to pull it up again.
Ah, okay.
I did, and I did look at
You
the,
don't have the facts before you. What about the president of the bar? I'm sorry to rush you like this because we don't have that much time.
What is the question, Sir Dennis?
The question is based on the possibility that you read the synopsis that we said.
Yes, I've read the synopsis, having had alerted to the fact that this might happen.
Right.
I don't know how equipped that makes me, but I'll do my best.
Well, the first question is this. Can a court narrow the issues without further information?
Should have gained popularity from being, what is this? From being, from going to court.
Is that Tara? Tara, thank you. Sorry about that.
Yeah.
You're asking if the court can unilaterally, I think that the issues.
No.
Yes.
No. Can the court narrow the issues, make a decision without further information? That does not necessarily imply unilaterally.
Yes.
But
is that a can or an ought?
If further information required, having read the claim supported by documents and the defense supported by documents, which is reflected in the synopsis, is that sufficient information without more to narrow the issues in dispute?
I would say so.
You'd say yes. Good. Is there any contrary view? But I take that as no. So we move to the next slide.
Chief, who is the 3rd volunteer?
Oh yeah, please, yes.
it is Justice Dorval Gomez.
Okay, Justice Gomez. So there you go, Sir Dennis.
Okay, Justice Gomez, do you have anything to say?
I'm not sure I would call her a volunteer, but she's conscripted.
Yes, I've read it and I agree with President Parker that definitely I would be able to narrow the issues.
Good.
Yes.
So we go to the next slide. Now, I've given 4 alternatives, and these are not necessarily the only possible effective measures, but I wanted to invite a selection of what would be the most effective measure for narrowing the issues in this matter. So the options I presented can issues that are irrelevant to the main issue in dispute be eliminated? Can facts that the parties are not required to prove be identified? Is there an issue which, if determined, could resolve the case? Is there a legal principle relevant to the adjudication on which the parties agree? Or is there another effective measure that you have thought of?
I won't go into I wouldn't freestyle it based on the options given and the facts presented. I would say that the most effective measure in the circumstances would be C on the facts, identifying the issue which could determine the outcome of the case if resolved.
Okay, fine. Justice Gomez, what is your view?
I agree with that as well, but I also think that there might be some facts that the parties are not required to approve, but I agree with Mr. Parker as well.
All right, so let's go to the next slide. Now, having said that there's an issue which, if decided, could be resolved. I have given four options as to which is the most important issue that can be decided to have this effect. Well, A is obviously not relevant because you both said that there is an issue. So the first point was this: would it be necessary? Would the determination of whether the Black River was diverted before it reached the fish farm be the issue? Is there the question of how toxic was the effluent in the water? Or was it the complaint of the defendant? Was the defendant notified of the damage to the fish farm on the date it occurred? Now, or is there another issue? Which is the issue that you would choose to prioritize for determination to resolve the matter?
I would say C.
C, yeah. And Justice Gomez?
I am torn between B and C.
Yeah, I think that C is where you'd start, because if there is no breach in the statutory levels, then you get to the other issues after that point. If you have a breach, then you need to take the other matters in turn. But if you could resolve something definitively early on, that would be the principal question, I would say, if I had to pick.
Well, to save time, I would just indicate that I agree with you, because that fits in with the principle of an issue which, if determined, could resolve the case. Because if the defendant's allegation that the toxic levels of the water were within acceptable bounds, then the case has to be dismissed. So that is an issue. So see, and that comes around to the point, you see. The next slide, please.
So Dennis, before we go to the next slide, maybe because we did not share the pleadings, maybe you can give a little anecdotal evidence, because everybody only saw the summary. We couldn't redact the pleading, so maybe it would be helpful, because you've gotten, I think, 3 A-grade students in this class.
All right,
But
yes, okay.
maybe you should share.
Thank you, Peter. I was probably just a little bit shell-shocked. I was probably a little bit shell-shocked by the issue of trying to comply with time. I think I have just 6 minutes left. But if I'm permitted to go over a little bit, what the pleadings alleged, in a nutshell, well, it's a very brief statement. That the plaintiff had a fish farm which was fed by a river. Higher up the river, the defendant had a factory, and the defendant was permitted to discharge effluent into the river, but the effluent had to be treated, and so the level of toxicity had to be controlled. The plaintiff alleged that there was discharge in the river of high toxicity, which killed the fish in his farm. And the defendant put up a number of defenses. He suggested that the level of toxicity was within acceptable levels, but in any event, the river was diverted before it reached the defendant's fish farm, and that sort of thing. Now, but we have here now that the two star students here. Thank you, Kenneth Field. The two star students have identified an issue, which, if resolved, could have determined an aspect of liability. And so the question is, when and what would the court or should the court do? You've had
Larissa, can you go to the next slide, please?
Yes, yes. Thank you. No, go to the slide before. She was on the right slide.
Okay, sorry.
The slide before. You see? Now, here you have. After 56 days plus 12 weeks, you have the defense, and you've come to this conclusion. How does this impact the disposition of the case? And I've given 4 alternative forms of action. 1, does the court wait for the next regular case management conference and discuss at that conference steps that can be taken? Or, once the defense is analyzed, does the court on its own initiative issue directions for the parties to make submissions on the issue?
You've
Or,
just given a time check, sorry.
thank you, yes. Thank you. Or does the court fix a date and make directions for the hearing of the issue? Or does the court make an order resolving the issue? What would you think would be the appropriate way a court should manage the narrowing of the issues in this particular manner?
I would say C.
C.
I would see.
Yes. Well, that's it. But you see, so here you have a case, a situation where, and you see, and again, it comes back down to how the enforcement of performance standards in the court. That is one of the reasons why I've often advocated that the most important cultural change for the implementation of the rules is the acceptance of the principle of measurable performance standards. Because if the defense was filed within 56 days of the matter being filed, you see how quickly after the filing, the court is in a position to take a step to resolve the matter, dealing with several issues of the overriding objective. I don't know, this is just an example. There are several other examples that could have been given, but I've now reached my time allocation. So let's go to the last slide. Well, this brings down to 2 simple thoughts. Study the pleadings, and then that also would require the study of the documents disclosed, and maybe if things are not resolved that early, to study the witness statements. But the court must communicate with counsel before the case management conference and give counsel a checklist which they can reply to the court in writing, addressing the matters which will assist in identifying the issues and narrowing the issues for determination. So those will be 2 important takeaways. The analysis of the pleadings and appropriate communication with counsel prior to the case management conference. So I think that I can end my presentation without more than 1 minute over the allocated time.
Thank you, Sir Dennis. But we have you're on time, but we have some time. We have we have about 8 minutes for any Q&As.
Okay.
Remember, that's part of your session. So
yes.
the PowerPoints are all down. So if anybody has any questions to Sir Dennis, or otherwise, this is our last opportunity to do that. I just wanted to say that what Sir Dennis has simplified. In fact, the pleadings may have been described as prolix because they ran several pages, right, Sir Dennis?
Yes.
Yeah, so these pleadings are from a real case, and they ran, I would think, over maybe 15 or close to 20 pages in all.
Each. Yeah.
Each. And they had all sorts of, when Sir Dennis said several other defenses, but it all reduces itself, as you all saw, to could have reduced itself to a simple analysis and intervention.
Peter, thank you for that, because that was the other point that could have been made. The two other points that could have been made is that the plaintiff annexed to the statement of claim the key document, annexed the certificate of the experts who tested the water. So that was on the record.
And that report said,
go ahead.
That the levels of toxicity were over the standards.
Yes. So the court had that. Now the defense, although denying that, did not allege that another consultant had been involved in making any studies, nor did it support any alternative document. So that would be an issue which was amenable to a quick resolution, because the court could have called the matter, and I would imagine that the witnesses would have been the expert for the plaintiff and maybe a staff member or other of the defendant. And the court would then have an opportunity to make a decision on that matter. But as Peter said, the pleadings were prolix. And even the plaintiff had about 4 different causes of action, and the defendant had found, I think, about 6 or 7 different defenses to raise. And a court could easily have got trapped into dealing with all of these matters if the concept of identifying what is the issue for trial did not predominate the thinking of the court.
I think the lesson here is that judges must not be intimidated by the pleadings. You see very prolix pleadings, you see very lengthy pleadings, you cut through the chase and you identify if there is a single issue that can resolve this dispute. Grasp the nettle, identify that issue, require submissions on that issue. And even if you can go to trial on a single issue and ask for evidence to be produced on that issue and hear that evidence. Because if it is going to resolve the entire case, if it is a knockout blow, then you stand a chance of ending the case without having to wait through all the other causes of action and defenses on the case. So that this case is actually a good example for the benefit of narrowing issues.
Well, when you see the plaintiff also was very thoughtful. All the claim was prolix. The plaintiff annexed to the claim a map of the river, so that if the issue of the toxicity of the water was determined, the chances of going to court was greatly reduced, because there was little chance of the defendant establishing that the river didn't pass the plaintiff's fish farm.
And so, Dennis, when we come to part 25, which I think we may deal with in one of the sessions to come, you will see that among the court's powers are not just to narrow the issue, and actually that's, so Dennis made the point, is actually the first thing listed in the list of things to do. The first thing is narrow the issues. But then it also says determine the issue and the priority in which issues can be determined.
Yeah.
So you can pull out a single issue under your case management powers and say, I am going to decide this issue, give directions, decide the issue, and what can happen is, with the resolution of that issue, the case can fall apart, or liability may be conceded or agreed, and then it goes to assessment and so on and so on. But part of what we want to say as we end is that what we hope at the end of this session is that you see how, starting with the overriding objective, it feeds into everything. And what we have left out with the fish farm case, which we want to put in at the back end now, is what the president spoke about. If there were, for example, pre-action protocols, this disclosure would have come before. Then the pleadings may have been narrower, but you would have had everything you needed up front. And also, it may have been seeing the issue. You can take an intervention and say, all right, do you want to mediate this issue? Do you want to go to arbitration on this issue? Do you want to get a early judicial evaluation on this issue? So that part of what we try to do today is to demonstrate, A, the centrality of the overriding objective, how in coming to a just disposition of a case, ADR can assist, and as well, how central to achieving that purpose of the overriding objective is in narrowing of the issues. I think we are close to time, Chief Justice. My clock says it's 8:08 in Trinidad and in the Eastern Caribbean, which means it's 7 o'clock your time. So maybe the last word, President, you then, Sir Dennis, and if the Chief wants to say something to close off.
Nothing much from me. I think that the whole idea, I hope that the whole idea of how the overriding objective is linked to pre-action protocols and to alternative methods of resolving disputes, and to the early narrowing of issues, how they all form a part of a single overarching matrix. Because as you see, as we go through, we didn't approach the court, the rules by looking at part 1, part 2, part 3, part 4, part 5. You have to see how various things link together in a single theme, a single thematic kind of matrix. And that is what we hopefully attempted to accomplish today.
So Dennis?
Well, I can make 2 thoughts. One, to support what Adrian said, because it's important to see the rules as being interconnected. And they're all interconnected through the overriding objective. And if that is sort of absorbed into the litigation culture, it makes a tremendous difference. But I must also say again that these issues ought not to cause the bar to feel that their livelihood is threatened, or that they're, because I think that as I've said many times before, and I think Adrian said it earlier as well, what is more profitable at the bar? To have 20 cases open for 5 years, or to close 20 cases every 6 months? And so I think that in terms of the, and not only that, not in terms of your own profitability, think of what it does to the society and what it does to the public perception of the quality of justice that they're getting. So these are issues, I think, which are all very useful in creating a better framework of social.
And so then it's fundamentally what it does for the court users, who are our primary customers, who want their work done quickly and at the lowest cost. So we are here to, all of us are here to serve our primary customers. In the case of attorneys, their clients, in the case of the court, their court users. I'll pass it over to you, Chief Justice, to close. But just to say to everyone, there are 178. At times, I think we went past 200 participants, which is brilliant, Chief Justice and President of the Bar. We thank you for the opportunity. There is an evaluation that I hope will be put in the chat now before we close. I think Larissa has sent it to your person in the Bahamas, and I hope they can post it now. We ask if everyone is electronic evaluation. It helps us if you fill it out. And if you can do so, we really appreciate it. Chief Justice, I think you can close us off for the evening.
Yes, thank you very much. Again, a very informative and instructive presentation. And I hope that the participants will see how these rules are interconnected. And it is a little bit more than just seeing what Part 1 says and what Part 5 says and what Part 6 says. So thank you very much indeed. I just want to remind everybody that the next CPR training session is the 9th of March from 4:30 until 7 p.m. And we will be covering the subjects in parts 2 to 6 and 9 through 17 at that time. Again, trying to adopt a thematic approach. So you will be receiving notice of this. The full training schedule will be on our website as of tomorrow, late afternoon. So you'll be able to plan, I hope, going forward. We do have another 11 sessions, and we're still on schedule to promulgate these rules on the 16th of May. So that I'm resolutely committed to that. So as I think the President said, you can't really learn to swim until you jump in the water. And that is what we are going to do. It's time we catch up with all of our regional friends throughout the Caribbean. So please make a note, the 9th of March, you'll be getting the notices, fill out the evaluation form. Thank you for participating and joining us tonight. If you have any suggestions as to how we can improve it, please pass it on to myself or to the registrar or to our administrator, Mrs. Nicoya Neely. Thank you again to Sir Dennis, President Saunders, and Justice Jamadar, and I wish everyone a very good evening.
Good evening.
Good evening, everybody.
Okay, bye.
Bye.
Bye-bye.